Presiding Officer, this year marks the 20th anniversary of the passing of the Scotland Act 1998, an act that gave effect to the overwhelming wishes of the Scottish people as expressed in the devolution referendum of the preceding year. As such, it carries with it a weight and political legitimacy, perhaps more normally associated with a written constitution. While devolution has been and remains a process, the existence of this Scottish Parliament is the settled will of the Scottish people. For my own and subsequent generations, and I say this as the first member to speak in this debate who was not old enough to vote in the devolution referendum, this Parliament has been and remains a permanent fixture of adult life. It is the centre of Scottish civic and political life, and indeed this is a view held by a majority of people in Scotland as reflected in surveys of public opinion. Consequently, any proposed changes to the competencies of this Parliament are of a fundamentally different category to any other matters that come before us in this place for consideration. Presiding Officer, as things currently stand, the UK Government's European Union Withdrawal Bill presents a challenge to the powers and legitimacy of this Parliament, unprecedented in the 19 years since it was reconvened. That the powers of this Parliament are under threat is not in dispute. The Finance and Constitution Committee of this Parliament reported with unanimity that the proposals contained within Clause 11 of the European Union Withdrawal Bill, as introduced by the UK Government, are, and I quote, incompatible with the devolution settlement in Scotland and fail to fully respect the devolution settlement. Presiding Officer, it remains the case that the best way to remove this threat to Scotland's devolution settlement is for Clause 11 to be amended to the satisfaction of this Parliament and legislative consent to be subsequently granted for the EU Withdrawal Bill. This represents the most efficient and elegant solution to the current constitutional impasse. However, this can only be achieved if the UK Government grasps that this debate fundamentally concerns a matter of principle, namely that decisions regarding powers devolved to this Parliament must remain with this Parliament. If I can make a bit more progress, please. An agreement should be achievable. However, the actions of the UK Government since June 2016 do not give cause for optimism. Meetings of the GMC have often been irregular. Assurances of a joint approach ahead of Article 50 were shown to be hollow, with the UK Government's position presented to the devolved governments as a fait accompli. And amendments proposed by the Scottish and Welsh governments, which could have allowed legislative consent, were dismissed by the UK Government. From this long, dismal sequence of repeated rebuffs, it is clear that the UK Government does not view the UK as a partnership of equals, as Theresa May once described the relationship between the UK and devolved governments. And rather than Scotland being invited to lead the UK Government now seeks to impair this Parliament's ability to lead Scotland. Presiding Officer, while time does remain for an agreement between the Scottish and UK Governments to be reached, we are now running out of track, as the EU Withdrawal Bill will shortly be entering its concluding stages at Westminster. Therefore, it is incumbent upon the Scottish Government and this Parliament to make preparations for all eventualities. The introduction of the UK withdrawal from the European Union Legal Continuity Scotland Bill represents a correct and proportionate contingency measure should agreement not be reached. It is correct in that it will enable legal continuity post-Brexit and safeguard the powers of this Parliament. It is proportionate in that it contains a mechanism for its own repeal should agreement on Clause 11 be reached between the Scottish and UK governments. On the issue of the timing of the introduction of the Continuity Bill, had it been introduced prematurely, the Scottish Government would no doubt have been criticised, with perhaps some justification for attempting to prejudge the outcome of negotiations with the UK Government. However, the bill has been introduced as late as reasonably possible, when account is taken of both the 4-week lying period prior to royal assent that the bill would face if enacted, and the earliest date that the European Union Withdrawal Bill could be passed at Westminster. Presiding Officer, this being a Stage 1 debate, we are of course being invited only to approve the general principles of the Continuity Bill. However, I do wish to state that I recognise the legitimate concerns of members regarding scrutiny. I therefore welcome the work of both the Delegated Powers and Law Reform Committee and the Finance and Constitution Committee, which is already underway. And I further welcome the formal role for the Finance and Constitution Committee at Stage 2. This is of course not ideal. However, nothing in the entire Brexit process can be described as ideal. Presiding Officer, this is a bill I would rather we were not required to consider. I voted Remain along with the majority of my Renfrewshire South constituents and the overwhelming majority of the Scottish people. Being stripped of our European Union citizenship against our will is an offence to democracy in Scotland. To be faced with a UK government seeking to unilaterally strip powers from this Parliament is intolerable. Presiding Officer, the Finance and Constitution Committee was clear. Clause 11 represents a fundamental shift in the structure of devolution. It is incompatible with and fails to fully respect the devolution settlement, and the committee is not in a position to recommend legislative consent on the withdrawal bill. The fundamental issues that led to the committee reaching these conclusions have not, as of yet, been resolved. If ultimately we must withhold legislative consent, then we will require our own legislation to safeguard this Parliament's powers and to ensure the stability and continuity of our laws after Brexit. It is on that basis, and with regret that we find ourselves in this situation, that I support the general principles of the UK withdrawal from the European Union Legal Continuity Scotland Bill.
Thank you, Mr Arthur.